I'm Ben Meiselas from the MeidasTouch Network. Washington, D.C. Federal Judge Tanya Chutkan just denied Donald Trump's motion to recuse her from the case. She is presiding over the prosecution brought by Special Counsel Jack Smith, where Donald Trump was indicted in Washington, D.C. for his attempt to overthrow the free and fair election in 2020. Donald Trump said that Judge Chutkan was biased, that she could not be impartial, and Donald Trump cited statements made by Judge Chutkan in two cases that she presided over involving sentencing for January 6th insurrectionists, where she addressed arguments made by the insurrectionists where they said that their culpability should be mitigated by the fact that they were following the orders of Donald Trump and that they believe that at that time, a sitting president wanted them to engage in the unlawful conduct, and they thought it was unfair that they were being prosecuted and sentenced, but Donald Trump at that point in time had not been prosecuted and still has not been sentenced yet. So in those cases, Judge Chutkan had to listen to those arguments, consider those arguments per her duty and obligation as a judge, and ultimately she rejected those arguments. And she said, while it may be true that the individuals who provoked the insurrection to take place, she's parroting the language of what the insurrectionists were arguing. She goes, while that may be true, it is not the case that your culpability is less. You're both adults, committed crimes. You need to face accountability and face the consequences of those crimes. So one of the things that Donald Trump very peculiarly argued, and I think it was really in bad faith, is he argued that Judge Chutkan's statements, which were made during sentencing of these insurrectionists, Trump argued that they should be viewed as extrajudicial statements. And Trump claimed that Judge Chutkan must have formed her opinion based on reading news articles and reading reports outside of the court, because the standard for extrajudicial statements made by a judge is a lower standard for recusal than the standard for intrajudicial statements made while a judge is acting in the capacity of a judge. So if they were extrajudicial statements, if Judge Chutkan made these statements, I don't know, in an interview with the media, or she made it in the cafeteria and somebody overheard her make statements, the question would be, and the standard would be, is there an appearance of impartiality such that it could undermine the kind of credibility of the judge in a specific case? Whereas if it's an intrajudicial statement, the standard is there clear and convincing evidence that the judge has demonstrated clear antagonism toward a potential defendant, in this case, Donald Trump. So Judge Chutkan immediately rejected out of hand in this order Donald Trump's claim that it was an extrajudicial statement, and she claims no, they're intrajudicial statements that were made in two cases. One was United States versus Robert Scott Palmer, an insurrectionist, and another one, United States versus Christine Priola, where they both made the same arguments, blaming Donald Trump for their behavior. And she said that she was obligated, it was her obligation to listen to their arguments, to address them, and then she ultimately rejected them. That does not create any impartiality, and certainly not by clear and convincing evidence of impartiality based on strong antagonism towards Donald Trump. And so she rejected the recusal request. I want to show you how Judge Chutkan starts off this order, because it's very powerful indeed. Before this court is defendant Donald Trump's motion for recusal of District Judge Tanya Chutkan pursuant to 28 U.S.C. Section 455. For the reasons set forth below, recusal is not warranted in this case, and the court will deny the motion. Here's how Judge Chutkan describes the background of this case, the background of this motion, the background of the January 6th insurrection. Defendant Donald Trump's motion relies on statements the court made during the sentencing hearings of two individuals convicted for their conduct on January 6, 2021. On that day, as the D.C. Circuit has described, and notice this, she knows that Donald Trump's going to appeal everything, so she goes and she cites, here is what the Court of Appeals, here's how they describe January 6th. On that day, as the D.C. Circuit has described, quote, a mob professing support for then-President Trump violently attacked the United States Capitol in an effort to prevent a joint session of Congress from certifying the Electoral College votes, designated Joseph R. Biden the 46th President of the United States. Quote, the rampage left multiple people dead, injured more than 140 people, inflicted millions of dollars in damage to the Capitol. Then Vice President Pence, senators, and representatives were all forced to halt their constitutional duties and flee the House and Senate chambers for safety. What I appreciate her citation there most about is also mentioning the fact that people died on that date as well. And we should never forget that. Over 1,000 people have been charged in this district with crimes related to their participation in the January 6th attack. While many of those cases are ongoing, hundreds have resulted in misdemeanor or felony convictions, with sentences ranging from probation to years of incarceration. Dozens of January 6 defendants have appeared before and been sentenced by this court before Judge Tanya Chutkan. Defendant's motion refers to two of them. So then she talks about United States versus Palmer, and then she talks about how Palmer's main argument is that it's unfair for him to receive a significant sentence when the people whom he saw as its instigators would probably never be charged or convicted for their roles. He said that he went to the Capitol at the behest of Donald Trump and that Donald Trump told him to take action. And then the court says, at the hearing, at sentencing on December 17, 2021, the court acknowledged those arguments and ultimately rejected them. The court then goes on to talk about another case that Donald Trump cites. One of the things the court does here as well is it makes it clear that Donald Trump cherry picks quotes from the court. And so the court gives the full context of what was actually said and makes it clear. What the court was doing was restating what the arguments were that the court then ultimately rejected by these insurrectionists. And Donald Trump cherry-picked it as though the court was going to be deceived by Donald Trump's cherry-picked portions of what she said. That's United States versus Priola, the same thing. So then the court sets forth the legal standard that I talked about. The Supreme Court has held that a judge's statements made in a judicial setting and reflecting opinions formed by the judge on the basis of facts introduced or events occurring in the course of the current proceedings or of prior proceedings do not constitute a basis for bias or partiality unless they display, here's the standard, deep-seated favoritism or antagonism that would make fair judgment impossible. That is because such statements often reflect information that the judge properly and necessarily acquired in the course of the proceedings and that was necessary to the completion of the judge's task. After all, if a court did not form judgments about issues in a case, then it could never render decisions. Consequently, statements originating from such intrajudicial rather than extrajudicial sources require recusal only in the rarest of circumstances. So then the court explains these were indeed intrajudicial statements. The court rejects Donald Trump's conspiracy that it's based on statements that she gathered from reading news reports and articles. And then Judge Chutkan states that she was duty-bound to say what she did because that's her job as a judge, to form opinions, to listen at what's taking place in sentencing, and to make rulings and decisions accordingly. Conclusion, for the reasons set forth Herein, defendant Donald Trump's motion for recusal of District Judge Tanya Chutkan, pursuant to 28 U.S.C. Section 455A, is hereby denied, dated September 27th, 2023, signed Judge Tanya Chutkan. Check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch for exclusive content there. Also, subscribe to our YouTube channel, and wherever audio podcasts are available, search MeidasTouch. That's patreon.com/MeidasTouch. Have a great day.
Love this video? Then you'll love the MeidasTouch podcast. Listen as my brothers and I break down the latest news and chat with top political leaders on the fastest growing pro-democracy podcast in the world. New episodes drop every Tuesday and Friday. Add the MeidasTouch podcast right now wherever you listen to your podcasts.